every so often we come across a court case which doesn't just seize the attention of Nigerians across the country, but spills across the world. And so it's been with the case of Senator Natasha Akpoti-Uduaghan, the Nigerian lawmaker from Kogi State, who's been embroiled in a legal tussle with the Senate following her suspension in March. And now it's come to this. Did the Federal High Court in Abuja order the Senate to recall Senator Natasha Akpoti-Uduaghan from suspension, or did it advise the upper chamber or recommend it to do so? Well, as has become almost customary with many judicial pronouncements in this country, lawyers and analysts are in a twist over this judgment. Some legal eagles are arguing that the judge did not necessarily order her immediate reinstatement, as is being reported, and that the court's judgment did not override the Senate's constitutional powers to discipline its members. And given that the court ordered some restitution, this would have to take place before the Senate would consider reinstating Senator Uduaghan. But already, Senator Uduaghan has reportedly told her supporters that based on the judgment of the court, she intends to resume work at the Senate on Tuesday. So are we heading for another full-blown conflagration? Well, for more on this, I'm joined now in the studio by the lawyer and member of Senator Uduaghan's legal team, Aja N. Aja. Thank you very much indeed for coming in.
Thank you.
So is the court asking the Senate to consider recalling Senator Akpoti-Uduaghan from suspension, or is it ordering the Senate to recall her from suspension?
Well, the language of the judge on Friday amounts to an order that the Senate should recall distinguished Senator Natasha. I say this, if I quote the judge correctly, not paraphrasing. She said the last sentence she read in her judgment is, in my view, or rather, she said the Senate can and should recall Senator Natasha Uduaghan, the plaintiff in the matter. For me, it's not advisory because the court is not empowered to give advice to an arm of government, rather to issue proclamations and pronouncements that are enforceable in law. So I think what the judge is basically, it's all a matter of stylistics. Some people, some judges would, and do not forget the context that the judge said that the full judgment would be made available in print this week. So what she did was to give a brief version of it, a summarized version of the judgment. Most times they just go ahead to tell you the orders they are making without giving you the reasons, the ratios. So by this week, if you get the certified copy or the enrolled order of the judgment, then we will see the reasons behind her pronouncements. But then she said that the Senate can and should, and once a body that is in a position to issue directives said you should do this, it does not leave it to your discretion. It means you must do that.
Well, as you said, as of now, the judgment, that certified true copy has still not been released. So how can you be absolutely sure that this is what the judge meant to say or actually said? I mean, how problematic is it that it takes so long to release this judgment? Because it makes things more uncertain, and you have, lawyers on the other side and, members of the National Assembly saying, well, she didn't say that.
Well, it's a matter of bureaucracy. In some courts, the moment the judge is reading the judgment is ready. The paperwork of the judgment is already concluded. And once after the judgment, the judge can tell you, just apply now, you will get a certified copy. But in this instance, the judge said that she would make available the judgment this week. She was emphatic to say this week. Let me also say something. The fact that there is a binarity in interpretation applies to every judgment. However, the court said something which is very key. The court said that yes, the Senate, Parliament has the virus, the authority to discipline its members. However, such punishment as Parliament can make must not be inconsistent with the provisions of the Constitution. Section 1 of the Constitution, sub 3, is very emphatic that any rule, law, or order made that is inconsistent with the provisions, either the letters or the spirit of the Constitution, is to the extent of the inconsistency null and void. And the judge was very emphatic in saying that fine, you can discipline your members when they go off the line, but then it must not exceed 14 days. And there is a long line of judicial precedents for this, starting from the period Dino Melaye and his group went to court to challenge their suspension in 2010, flowing to even by March. This suspension was made in March. Exactly 1 year ago, Senator Abdul Ningi was suspended for making an allegation that is criminal in nature, that Parliament, the Senate, padded the 2024 budget. He was suspended for 3 months. However, upon receipt of the letter from the attorneys to the distinguished senator, the Senate rescinded his decision and recalled him immediately. Now, they knew that they were swimming against the tide because, come to think of it, the Senate is playing, they're just acting God. And I say this advisedly. Why do I say so? The Senate has a legal department, legal unit. And I'm sure that the Senate president also has a legal advisor who is a distinguished learned. But I wouldn't be surprised if, in the abundance of legal advice available to them, they choose to play politics over everything. How? Look at the history of these suspensions from the days of Dino till today. The matter of distinguished Senator Uduaghan appears to be the least severe. What was she suspended for? Breach of the rules. Basically disrupting, according to them, the proceedings by insisting on making her voice heard on matters of privilege. They said, no, you cannot do that when you are not sitting on the seat allocated to you. And she said, I was just informed of this change in sitting arrangement this morning. Here during plenary. It's unfair that you hear me out and then you can overrule me. But the Senate, in its own wisdom, said, no, we cannot hear you out. And that was the beginning of this. And then here we are. Judgment has been passed. And the judge said, I cannot put my signature on any law suspending or any order suspending any resolution of the Senate suspending a senator in excess of 14 days because this matter transcends Natasha. The victim of this suspension are her constituents.
Yeah, but did she actually say 14 days?
Yes, she said it must not be in excess of 14.
Because, I mean, she made the point that since lawmakers have a total of 181 days to sit in Parliament, suspending a lawmaker for roughly the same length of time effectively silences the voice of that constituency that she represents. But it didn't. I mean, that's what we're hearing so far. As I say, we haven't seen the judgment.
No.
But I mean,
I was there in court. I'm not speaking from the point of hearsay.
Right.
I was there in court. Right. In fact, I was the number 2 on our list, on the plaintiff's list, after the senior advocate leading us. Let me make it clear. The judge specifically said that any suspension, and it's not just this judge, and the judge's hand is tied in this instance. Why? Because in 2018, when Senator Ndume was suspended, he approached the court, and he got to the court of appeal. And once a matter has been settled at a superior level, the court below are bound by what we call stare decisis precedents. So the meaning is that the court couldn't have departed from that ratio that any suspension in excess of 14 days is unconstitutional.
Right.
In fact, in the case of Abdulmumin Jubril, the court, Justice Soho, said that it was an abuse of democracy to suspend a lawmaker in excess of 14 days. So we have a long line of decided authorities that the court could not have departed upon.
Right.
But as for whether she made it clear that it must not, yes, she said it was excessive for exceeding 14 days.
But I mean, you are a lawyer,
yes,
obviously. What are the limits of an arm of government that interprets the law over another arm of government that makes the law? Can the court compel the Senate over its internal disciplinary rules? I mean, we've seen the courts consistently saying to political parties, you go sort out. I mean, obviously, it's not the Senate is not the same thing, but you would imagine that the Senate's powers in that regard would be stronger than even that of a political party.
No, because the powers of the court are vested in the court as a matter of constitutional provision. Remember? So the court is there to interpret, to adjudicate on conflicts between parties, between institutions. Now, when a member, in fact, if you are a member of what we call Warako Group, an association, village association, and the constitution of the village association says that if A happens, B should happen. Okay, fine. We have cases where the courts have held that the court cannot interfere in the internal running of political parties. Fine? But there are situations where the political party goes against its own constitution to take actions. The court will intervene because the court will now be invited to interpret the action of the political party in line with its constitution. So it's already there, the separation of powers fine, the legislature makes the law, the judiciary interprets the law made by the legislature. There is no limit to that interpretation. So it is also very unfair, I must say this now, that the body that makes the law is the one that has serially abused the law. Because otherwise, why wouldn't they take precept from the fact that since 2010, that the law courts have consistently denigrated this act of suspending senators or parliamentarians in excess of 14 days. Yet, the last one that happened in the House of Reps was in 2018. That was Jubril's matter. But Senate has they suspended Ovioma Gege 2018. They suspended Ningi. They suspended Ndume. Ningi's own happening last year, just March last year. And this year again, we have Senator Natasha. Is it that there is a dearth? Is it that there is a scarcity of quality legal advice counsel available to the Senate, or that they prefer to play to the God factor in this, all of this, to determine? Because at the end of the day, do not forget that the same people who are pushing for Senator Natasha to be silenced also took it further to try to attempt a recall, which floundered and failed miserably. So they are, if they are still putting on, stoking the embers of opposition against her coming back to the Senate, it's all still within the same script. So we are not surprised. But then when we get to that bridge, we'll cross it.
Right. Now, obviously, one of the things that we talked about at the outset was the fact that the judgment has not been released. I mean, you may have been in court. Many people were not in court, so they don't really know. But does it also add to the confusion the fact that an issue of contempt has been mixed in with this case?
Well, let me address that issue of contempt. You see, it's actually funny, if not ridiculous, plainly ridiculous, that they say in law that he who seeks equity must do equity. He who comes to equity must come with clean hands. The defendants applied to the court to commit distinguished Senator Natasha on account of her having written a Facebook page, publishing a Facebook page apologizing to the Senate, even though they say it's satirical.
Right. Satirical.
Yes, but the same people who made that complaint before the judge were in contempt of a subsisting order of court, which barred them from taking further disciplinary actions against, made by the judge that handled it first, Justice Eguatu. Now, the judge here on Friday said that upon her assuming jurisdiction over the case, that all orders lapsed. Fine, but before the lapsing of the order, they were already in contempt because the order was made, and a day or two afterwards, they now went ahead to suspend her. And then the Senate president, of course, raised the issue of likelihood of bias against the judge, upon which he recused himself, and the matter had to come to the current judge. So the judge has made a pronouncement that what you wrote on your Facebook page, even though we don't agree with that, we are still, because at the end of the day, it is the ratio, the reason behind the pronouncement that you can appeal, not necessarily the pronouncement. When we get that, we'll study it and we advise the client accordingly. The judge said, you made a pronouncement, you made a publication, and that publication substantially addresses what is before me. But we do not agree with that. Because the Senate said a condition for the recall of distinguished Natasha is for her to make an apology to the Senate. And she felt that making an apology would undermine her case. So in the spirit of bonhomie, she now did what she did. Say, okay, I want me to apologize. Okay, this is my apology. Take it for whatever it is worth. And the judge felt that it was contemptuous. And the judge said, okay, since you did this, therefore, do this, pay to the federation account, this, and then also make publications in 2 national dailies. However, we are also of the view that even if we concede that the publication amounts to contempt, the penalty was excessive.
Right.
Just as the over 2 weeks suspension was excessive, the judicial pronouncement of her paying 5 million naira as well as making publication in 2 newspapers we believe that it's excessive, but we will take that up.
Yeah, but that one was pretty clear, though. There's nobody who has any issue about the clarity of that judgment.
Yes.
Why is it that we have now come to a place, and it's almost become customary with many judicial pronouncements in this country, that lawyers always end up in a twist about what the judgment is actually saying? I mean, is there a sense that judges are deliberately fudging their verdicts? Because I don't mean forging, fudge.
No.
Yeah, F-U-D-G-E, yeah. Deliberately fudging their verdicts, because the court is supposed to resolve issues, not deepen conflicts.
Yes. Fine. On the day the judgment was given, the lawyer to one of the parties, Elenesik, had a media exposure during which he said that the judge recommended that Senate should recall her. But then my view on that is that even that language does not exonerate them. How?
Right.
If you look at section 318 of the 1999 Constitution, which is the interpretation...
Briefly, because we're almost out of time.
Okay, which is the interpretation section. It talks about what a court decision means. It means a conviction, it means a judgment, it means an order, it means a sentence, it means a recommendation. So a recommendation is not used in the loose sense, it's used in the technical sense, which implies an obligation to obey that.
So it's an order, basically.
It's an order.
So why don't you just call it an order and not a recommendation?
Well, that's why I say it's a question of stylistics. Maybe the judge...
Right.
And let me also point one thing out. The judgment lasted for about 48 minutes. The issue of the preliminary objections raised by the defendants were canvassed and treated. The issue of the contempt was treated. The substantive matter, which is the suspension, took less than 5 minutes out of this 48 minutes. I'll leave you to make your own inferences.
Okay. Well, we will make further inference when that certified true copy of the judgment comes up. But I thank you very much indeed for coming in and for attempting to explain it as lucidly as you have to us. Aja N. Aja is a lawyer and member of Senator Natasha Akpoti-Uduaghan's legal team. Thank you very much indeed.
My pleasure, sir. Thank you.
That's it for this edition of Arise Prime Time. Join us again tomorrow. From me and the entire team here in Abuja, bye-bye and thank you for watching.